and thank you for coming to the San Francisco Law Library to our free lunchtime speaker program. We hope that you'll stick around after the program and check out our library resources. We're happy to help you find anything you need today. First of all, I am Diane Rodriguez. I'm the director of the Law Library, and today we're pleased to welcome Judge Stephen Murphy, the presiding judge of the San Francisco Superior Court Appellate Division. He's also presiding over the Care Court on alternative Thursdays. And Judge Murphy is a Boston native. He graduated from the College of Holy Cross in Worcester, Massachusetts. I hope I say that right. And the University of San Francisco School of Law. For over 34 years, he represented plaintiffs in personal injury and employment litigation. He's a past president of the San Francisco Trial Lawyers Association, which voted him Trial Lawyer of the Year in 2008. He's also been named by Super Lawyers as one of the top 100 lawyers in Northern California. He's an accomplished author and is known for his gripping legal thrillers. His writing is praised for its impeccable plotting and lifelike characters, exploring the complexities of the legal system with authenticity and intrigue. His latest novel, Beneath the Gavel, is his first standalone legal thriller. He will have some for sale at the information desk after this, and you're welcome to stick around and purchase a copy and get them signed. He's also finishing his fourth novel now in the Dutch Francis series. Judge Murphy also serves as an esteemed member of our Law Library Board of Trustees, where we appreciate his participation and his insightful guidance into library matters. He's also a patron of the library and puts our reference team to work on legal history research, which is a lot of fun for us. You can find more about Judge Murphy and all of his books at his website, stephenmurphy.com. I highly recommend reading it. It's just so insightful. There's wonderful Q&A with him to get to know him a little bit better. But please join me in welcoming Judge Murphy.
Thank you. Appreciate that introduction. Just one correction. It's the website Stephen M. Murphy. If you don't put the M in, I don't know where you go. So I appreciate everyone showing up today. Let me start off with a brief survey. How many of you are authors? Raise your hand. 1, 2, 3. Well, kind of sort of raising your hand. All right. How many are lawyers? I've got some MCLE credit for you. Make sure you sign the form. How many are lawyer authors? Oh, okay. Good. So, how many of you, last question, how many of you read legal thrillers? A few more? Okay. Not all of you read legal thrillers. Well, hopefully you will after today. Not just my books. There's plenty of other books out there. So I've broken this talk down into two parts. First, I'm going to talk about literary concepts such as point of view, plot, theme, developing characters. And then I'm going to talk about how those concepts can apply to trial lawyers and how to use those concepts in informing your trial strategy. So let's get right into literary concepts. The first issue that we have to face as authors, I think, is setting. Where's your book going to be set? Is it going to be in the nitty-gritty urban setting or suburban or rural setting? And some authors like Agatha Christie set her books in a closed room where you have a limited number of possible suspects, but you know who they all are. Most books aren't like that. You have a more diverse set of suspects. So first decision, where are you going to set the book? Then next, what's the point of view going to be? And you have first, second, third person points of view. My first three books, which are in the Dutch Francis series, are all in first person. The last book, Beneath the Gavel, is in third person. First person has some limitations and some advantages. In first person, the narrator is present throughout the book. And I'm going to quote some of the statements by authors I've interviewed. My first literary career involved interviewing lawyer authors. So I wound up publishing 2 books with collections of the interviews. There was Law and Whether Holden Caulfield went to law school. And Steve Martini, who's a best-selling lawyer author, has stated when doing first person, that character, your protagonist, has to be on stage constantly. And you've got to be very careful because the reader can get tired of that person unless there's something to keep the reader's attention. To avoid boring the reader by the constant presence of the narrator, the author can use different techniques. And those techniques can expand the point of view. For example, protagonist may bare his soul to a psychiatrist, which happened in Presumed Innocent with Rusty Sabich, the main character. The protagonist can evaluate the evidence talking to the spirit of his deceased wife, which actually was very popular in Jeremiah Healy's John Francis Cuddy series of legal thrillers. Another way to do that is listen to tape recordings of the deceased. Richard North Patterson used that technique in Degree of Guilt, which was an enormous bestseller. As I said, my Judge Francis novels are in first person, and although Dutch is a lawyer, and although he hires a private investigator for all of his cases, he sometimes joins in the investigation more than a typical lawyer would. Just so as I'm going through the story, I'm not just relating what the investigator tells them, he's actually experiencing the same kind of revelations as the investigator. And I find that works much more effectively than having the investigator just simply relate the story to Dutch. My second novel about power uses tape recordings of sessions with a psychiatrist. So the victim is actually, you can hear her voice. And that's another technique to use to expand the point of view. In Beneath the Gavel, even though it's third person, it's close third person, meaning that the protagonist is the one the author is focusing on. And it's more like first person, except you use he, she, they instead of I. It has more flexibility to develop aspects of the plot. In addition to showing the lawyer protagonist preparing for trial, the author can also show the opposing lawyer, police investigation, other bad guys, even the trial judge. So in third person, you can expand that whole universe and use various strands for the reader to follow the plot rather than just from the point of view of the narrator protagonist. Information in third person can be withheld from the reader that the protagonist reveals only at trial. It's hard to do that in first person because if you hold back information the narrator knows, the reader's going to feel cheated at the end. So it's a balance between revealing information and what information do you reveal. And that to me is the biggest challenge on first person, because you want to be fair to the reader that they're getting the story, they're getting all the elements, the suspense, but you're not cheating the reader in the end. Let's talk about plot. Plot is generally defined as the sequence of causally related events in a work of fiction. And the key is causally. The late Boston lawyer author, George Higgins, viewed plot a little bit differently. He's the author of The Friends of Eddie Coyle. You may have read that book or seen that movie. He says the plot is strictly what the character encounters. First, how the character gets into or has already gotten into an extremely tension-filled, stress-packed situation at the time that the story begins. And secondly, what he or she does to get out of it. In terms of plot, you also can use subplots, and subplots can take different forms. The lawyer may be handling two seemingly unrelated cases that intersect at some point. The famous author you may have heard of named Clifford Irving, and he's not a lawyer, but he's famous for writing the autobiography of Howard Hughes and got prosecuted for fraud and spent time in prison. But he writes legal thrillers, and he wrote a book called Trial. He believed the strength of that book came from the readers wondering how is the lawyer going to get out of the mess he's in and resolve the dilemma of the two cases being so stunningly related. Another technique is to introduce a plot that seems related to the main plot, but turns out to be a red herring. How many have read Presumed Innocent? Few, okay. That is, you may remember there was a subplot in Presumed Innocent about the B file. And for much of the book, the reader believes the B file would hold a clue to the murder of Carolyn Polhemus. Spoiler alert, it doesn't. But it's very interesting, and it's a great sideline. Other subplots serve only to expound the theme or develop a character. In my last Dutch Francis novel, Abiding Conviction, I used two different subplots. One involved Dutch Francis' wife getting kidnapped, and the second involved his trying a murder case in which the defendant was a sitting judge. And he was forced to look for his wife and forced to try this case at the same time, which led to a lot of stress, as you might imagine.
That's based on an autobiography or?
Autobiography. Not yet. In dealing with the plot and revealing the plot, the cardinal rule that you'll hear if you ever go to any writers' conferences is you should show rather than tell. And what does that mean? Showing means painting a visual or word picture of what is happening, rather than just telling the reader, this is what happened. And I'm going to read a brief excerpt from my latest novel, Beneath the Gavel, which involves a judge who is in the courtroom presiding over a criminal arraignment and encounters his estranged father, whom he hasn't seen in 34 years, as the defendant in the murder case. So I could have just said Judge Ferdinand Pitt was shocked to find his father standing in front of him. But I tried to paint a picture of really that scene, and I got a lot of very good input from editors who helped me do that. So I'll just read briefly. Judge Ferdinand Pitt slumped in the thick leather chair behind the bench at the Hall of Justice, San Francisco's tired criminal courthouse, and stared down at the defendant standing in front of him, a man who looked like he'd seen better days. Caved cheeks, thinning hair, a gaunt face, his thin frame lost in the orange pants and sweatshirt he wore, his hands chained behind his back. He stared at the floor, not meeting Ferd's eyes. As the seconds passed, Ferd began to suck small gasps of air through his mouth. And that's the very beginning of the book. So those are the issues you're dealing with plot. With theme is generally defined as the central unifying idea, topic, or insight that a story explores, often revealing a deeper truth about human life or the world. One of the most common themes in mystery fiction and legal thrillers is crime doesn't pay. And that you see that in probably 95%. Sometimes the bad guy gets off. In one of my books, that's the case. I won't tell you which one, so I won't spoil it. But I try to turn that theme on its head. My books have different themes. Alibi explores the theme of how valuable friendship can be and how friendship can lead to pitfalls. And the plot very simply is Dutch Francis is contacted by a friend he hasn't seen in 20 years who asked him to take on the defense of a murder case. And he's at first feels complimented that his friend looked him up after all that time, and then starts wondering if his friend didn't have an ulterior motive. So that's where the story jumps off. The second book is about power, and I talked about themes. That theme is right in the middle, right in the title of the book. It involves claims of sexual harassment in the workplace and sexual abuse of a minor. So the theme is, of course, it's not about sex, it's about power. Abiding conviction is the one I related with the two subplots, and the theme involves how far will a husband go to rescue his wife? Will he break the law? Will he violate his code of ethics? And then Beneath the Gavel is somewhat similar, and in terms of theme, it's about, and this is my tagline, the judge is torn between justice and family, violating ethics to uncover the truth. And you can see that in the video that was shown at the beginning. So that's theme. Let's talk about characters. Many legal thrillers feature high-profile characters, either as protagonists or victims. For example, the characters in Richard North Patterson's Degree of Guilt are a television broadcaster as the rape victim and accused murderer, a famous novelist as the accused rapist and murder victim, a former Watergate lawyer as the defense lawyer. So those are all people that you can readily identify with, and elevates the story. And as I said, that was a huge bestseller. Michael Eberhard wrote a book called Against the Law, which has the murder victim being the governor of Hawaii, another high-profile character. David Baldacci's Total Control involves the chairman of the Federal Reserve Bank being killed in a plane crash. Well, that might happen. Who knows? Where things are going. And in that case, so in another book called The Legacy, a U.S. senator and candidate for California governor is murdered. Again, that might happen. The way things are going. One advantage of using high-profile characters is that the reader will immediately recognize that the stakes are high. With a low-profile character, which is really most people, the lawyer-author must take greater care to sketch them in a meaningful and compelling way. Because the reader will not immediately identify with the stakes faced by a low-profile character, these characters have to be brought to life with clear personalities, ambitions, and values. One example is by an Arkansas lawyer named Griff Stockley, whose main character is a lawyer named Gideon Page, described as a 40-ish, balding, self-effacing public defender. He has a dog named Woogie, a Colombian wife, and this is the part I can never forget. He has a penchant for timing his urination. I'm sure I would use that, but that's what that book was using to illustrate that character. Another literary concept to consider has to do with conflicts. Many mystery legal thrillers rely on personal conflicts among different characters. Generally, the conflicts are due to family relationships. For example, in Degree of Guilt, the accused is defended by her former lover and the father of her son. And against the law, the suspected assassin of the governor of Hawaii is the godfather of the prosecuting attorney. In Steve Martini's Compelling Evidence, attorney Paul Madriani defends his ex-lover who was accused of murdering her husband. And one of the most intriguing conflicts occurs in Philip Friedman's Reasonable Doubt, where the defense lawyer defends his former daughter-in-law who was accused of brutally murdering his son. Although these conflicts raise the stakes, they give by giving the attorney a personal involvement in the outcome, often they can strain credulity. And I think some of those did that, and it really is a fine balance. Beneath the Gavel, the conflicts I posed were all family ones involving Judge Ferdinand Pitt, his estranged father, son, his son, and his wife. So that's very much a family novel as well as a mystery. Next, let's talk about the climax of books in terms of literary concepts. Realism comes into play, especially in trial scenes. And the climax often is at the trial. But the decision to include a trial scene in a legal thriller must be considered carefully. Trials often are slow, tedious, and dull proceedings. Certainly, there are moments of high drama, and those need to be accentuated in fiction. The challenge then becomes to balance realism with drama. Too far a break from realism may lose the reader. Too little drama may bore the reader. So if the author decides to include a trial scene, then the next decision must be what parts of the trial to include. In John Grisham's Time to Kill, hundreds of pages are spent on jury selection. Personally, I thought it was too much, but that book sold millions of copies and was made into a popular movie. In Abiding Conviction, I included scenes from the preliminary hearing to build tension early on. And when I got to the trial, I had to be careful not to duplicate the witnesses who testified at the preliminary hearing. So I had to skip over some of those witnesses' testimonies at trial just to make it more compelling. And that's one of the challenges you need to be aware of when writing trial scenes. Finally, let's talk about the resolution of the book. Should a legal thriller end before trial, upon reaching a jury verdict, or sometime after the verdict? Of course, there's no set rule. It depends on the context, the characters you've developed, and how you want to resolve matters. Presumed innocent never went to verdict, since the judge dismissed the case during the trial. But the story did not end there because the murderer had to be revealed. And each plot will require a different strategy. So those are some of the literary concepts I wanted to throw at you. And before we talk about applying them to a trial strategy, I'm going to start by quoting Steve Martini, who wrote the foreword to my first book, Their Word is Law, which is a collection of lawyer interviews. He said, lawyers have always been storytellers. What is a trial but the story of conflict between two parties? And one general comment I would have for you trial lawyers is think about fictional elements and literary concepts when you're plotting your strategy for trial. How is what you're doing going to look to the ultimate decision maker, whether that's a judge or a jury? The first issue you have to decide is setting, or in legal jargon, venue. And that means which court do you file in, federal or state, as a starter? I practiced plaintiff's employment litigation before I went on the bench. And the general rule was stay out of federal court if you could. For a lot of reasons, one being you need a unanimous jury. And two, the judges are much stricter in doing certain things like granting summary judgment if you're the plaintiff, which you don't want. And in terms of the law, it's much more favorable for plaintiffs to be under California law, the Fair Employment and Housing Act, than Title VII in federal law. So that's the first issue you have to decide is the setting or venue. And which county are you going to file in if you're the plaintiff? Defendant doesn't usually get much choice in this matter unless the plaintiff files in the wrong county, which I happened to do one time. I had a case involving a personal injury of a golfer who was on a golf cart and got injured in San Geronimo Golf Course in Marin County. And I didn't want to be in Marin County. Juries aren't as generous there as some places. And so I filed in San Francisco. Never got a motion to transfer. I was shocked and wound up going to verdict, which I'll tell you a little bit more about that case in a moment. So what I'm going to do is I'm going to use some of these literary concepts and try to detail how I used them myself in trials I had before I took the bench. Next is the point of view. Is it first person or third person? And this is generally comes into play during opening statement and closing argument. I would recommend you don't use second person, saying you, because then you're talking to the jury and the golden rule prohibits that. So second person doesn't come into play when you're dealing with a trial. First person is tricky. I've seen some lawyers do it where they would take on the persona of, say, the victim, sometimes the deceased victim, and talk to the jury as if he or she is that victim. I can't pull that off. That to me would be really hard. I'm not a good actor, so that wouldn't work for me. Third person works much better. And in terms of point of view for a trial, and this is one thing I want you lawyers to take away from my talk, is keep track of whose point of view you're telling the story from. Whether it's the plaintiff, if that's your client, or the defendant, or both. But be clear on where you are in that continuum. In my golf course case, my client had been enjoying a round of golf with her boyfriend. It was a sunny day and she was riding along in her golf cart, which she'd done many times before. She played this golf course many times before and was on her way to the 12th hole when the golf cart suddenly tilted and tipped so much that it threw her out of the golf cart to the side of the road where there was a ditch that was 15 feet down. And she landed on a rock, a huge boulder, and fractured her scapula. So what I just told you is from my client's point of view. I didn't talk about the defendant. I didn't talk about her boyfriend. It was just from her point of view. And that's how I told most of my opening statement. But I also told it from the point of view of the maintenance worker. We'll call him Jose. That was his name. And he had been in charge of removing all the leaves from the path where the golf carts rode. And he said that he would do this every day, sometimes several times a day, and he'd blow the leaves into the side of the road where they would obscure the fact that there was a ditch going down 15 feet. And so he knew that people riding in a golf cart would not realize there's a ditch to the side of the road. And he admitted that. So that I kind of switched back and forth from point of view there after telling my client's story to the golf cart and the golf course story. Another example, I had a sex harassment case against 101 Casino up in Petaluma. My client was a waitress there. It's a card room more than anything. And she said her manager, her direct boss, when she was carrying a rack of chips for the card tables, would constantly comment to her that you have a nice rack while he was staring at her chest. That's just one of the many things that the manager did that constituted sexual harassment. So I told the story from her point of view as walking through the casino, carrying the chips, how that felt, how upset it made her, how she would go home at night and tell her husband about it and complain and think about quitting her job. Then I switched to the general manager of the casino, and he admitted in deposition the following. I asked him a question that I said, the motivating reason for your decision to terminate my client was her complaints of sexual harassment. Isn't that correct? To my shock, he said yes. So I had a retaliation claim built in. So I told the story from his point of view of how he kept getting these complaints from his subordinates about my client's complaints of sex harassment. And that he decided because of that, he was going to fire her, which he did. One final comment on opening statements. It's important whether you're doing an opening statement or writing a book to whet the appetite of the jury, but not satiate it. If you tell too much in opening statement, too much detail, you're going to lose the jury, just as you would lose the reader if you introduce too many characters at the beginning of a book or too many plot details. So it's important to keep the big picture in mind when you're giving your opening. Of course, in closing, you've got free rein to do whatever seems appropriate. Now, in terms of using the plot device, I usually refer to that as presenting the evidence. And the show and tell rule comes into play very strongly in a jury trial. Your goal is to paint a picture. And in my golf course case, I actually took that literally and had a medical illustrator paint a picture of my client's fractured scapula. And the illustrator did such a good job that the surgeon who repaired her injury admitted that that was an accurate representation of her, but he also said it looks like a jigsaw puzzle. She had so many fractures on her scapula that illustration looked like a jigsaw puzzle. So that was particularly effective. In my sex harassment case against the casino, one of the allegations was that my client's boss would show her this pen that's like an advertisement for a Viagra type drug. And you click on the pen and a plastic penis pops up. So it's kind of disgusting just to say that. But imagine if you had the pen.
Mhm.
So I thought, I got to show this. So I ordered the pen online. And I'll never forget handing it to the jury and having them pass it along and clicking it, and seeing their disgusted faces. And that was a prime example of showing rather than just telling. Another example was also a sex harassment case involving a paralegal suing her boss who ran the law firm. One of the allegations in that case was that her boss came by her apartment and told her to go out and get pizza. Well, take her kid out to get pizza, and he gave her a few dollars while he used her apartment for a tryst with his mistress. That was just the beginning. And then there was another time he asked her to make hotel reservations for him at a hotel in San Francisco. And the way this goes to show, don't tell is that he denied asking her to make those reservations, said he was in San Francisco by himself. And when I questioned him on the stand, he said he was alone the whole time, ate alone, etc. Well, I trusted my client. I thought she was telling me the truth. So I subpoenaed the hotel records. And it was a trial subpoena. So they didn't know I had the records even during trial. And the defendant lawyer admitted all these things, that he was alone and he never asked her to set up this affair. So I had a choice. I got the records, and it was quite obvious that he wasn't alone. There were 2 servings at dinner. There were 2 suitcases for a weekend in San Francisco. Everything indicated there were 2 people. And so I could have just submitted those records and said, he's a liar. But I asked the custodian of records to go appear at the trial so he could explain these records. And rather than just telling the jury what the records show, he actually displayed them and proved conclusively that this guy was a liar. And that turned out to be very effective. Final example on showing, not telling, is I tried early in my career, insurance bad faith case. My client lived in Fairfax, and their house got blown away during a huge storm while they were in it. And the problem with the case, from my point of view, was there was an exclusion for landslides or mudslides. So they wouldn't have had coverage with their insurance company. So I consulted an expert who said that the incident was caused by a wind-induced tree slide. Wind-induced tree slide. So my job at trial was to show how forceful the wind was. And one way I did that was first having my client testify to the trees going basically parallel with the ground when the wind was blowing. But the most effective part of that was in talking to my client's daughter. She said the wind was so bad, my hair was blowing straight up in the air. She had hair that went below her waist, so very long hair. And it turned out that picture of her hair blowing in the wind resonated particularly with the women jurors. Wouldn't resonate with me. But the women jurors really got that. And they were so focused on the win, I was able to prevail in that case. Next, literary concept I wanted to talk about is theme as it relates to trials. Again, this is the underlying principle, and a lot of lawyer programs talk about theme. So this is probably the one that's not as unusual. In personal injury cases, the theme often is profits over people. I had a case involving a construction worker. He was a scaffolder who was working on a large building in San Francisco and walking from one end of the scaffold to another when the scaffold collapsed, sent him 20 feet to the ground where he suffered serious injuries. So I had to show that the theme of the scaffolding company was not his employer, put profits over people. So that is an example of where you take a theme and you try to develop it throughout your case and show really what could have been done and why the profits were more of interest to the defendant than the safety of the people working on the site. And then also, if you have a similar theme or similar kind of case, corporate greed is a theme that's often used, particularly if you want punitive damages. I had one case, a molestation case against the Baptist church. And in that case, my 14-year-old client was molested by the church leader. And he testified that the leader would wrestle with him on the grass outside the church right after a service where everybody could see them. So my theme was, blind eye, that the church turned a blind eye to what was going on because they got very physical, and that resonated with the jury as well. In a sex harassment case, often the theme is as I said, my title of my book is about power. It's not about sex. And that applies in many different contexts. I had a case involving a woman who was having an affair with her boss, consensual. She tried to cut it off, and he wouldn't allow it, and continued to harass her. And at that point, I really had to bring home the theme of about power rather than about sex. Next, characters or witnesses, as they're called in the trial. The sequence is important. So if you can order the witnesses, and it's not always easy to do because of schedules and convenience, et cetera, but if you can sequence them in a way that builds on your theme and builds on your story, then that's the way to do it. In my Baptist church case, one of the most significant witnesses was a person who was put down as a reference by the molester when he applied to the Baptist church to be the youth pastor. And I called up this reference and talked to her and asked her if she'd ever been contacted by the church. She said no. I asked her, well, what would you have said if they asked you for a reference for this guy? She said, absolutely not. He's creepy. He does some strange things. And the church never contacted him. So I had her testify after the church talked about what a great guy this was. The pastor talked about how great a youth pastor the defendant was. And then I called this witness and really was very effective. In my case against the lawyer for sex harassment, I sequenced the testimony of the hotel custodian of records to be at the end of a day. If you can do, it's like the end of a chapter in a book, like cliffhangers. The author's goal is to get you to read the next chapter. In a trial, your goal at the end of the day is to have the jury leave with your case in their minds and having your point of view. So if you can sequence the testimony of the witnesses in such a way that it's to your advantage, that's the way to do it. I remember many trials where I would be watching the clock, just trying to get to the breaking period, and sometimes asking questions that were not all that important, just so that would be the last witness that the jury would see that day. Another thing you should do in terms of your witnesses is identify who can tell the big story. Sometimes it's not always obvious. I had one case that was an age discrimination case against Safeway, and we were all set to go to trial, and I sent a notice to appear to the CEO, who at that time was Peter McGowan, who you may remember from the Giants. And there was an objection, and the judge said he has to appear. And the reason he had to appear was he made the mistake of being quoted by a newspaper reporter that we've got to get these old people out of the company. And so I wanted him to testify. I could have called the reporter to just relay what he said to the reporter, but obviously his testimony was much more effective. And after the judge ruled he had to testify, the case settled. Turned out he was on vacation in Europe and didn't want to come. Another strategy that you can use with witnesses is pitting one witness against another. If you have multiple defendants, for example, you can have one defendant testify in such a way that it harms the other defendant. I had one case, personal injury case, where my client was at an accident scene where her son got in an accident. She was standing there. The CHP officer was beside her, and all of a sudden a car came screaming down the hill, blaring, skidding, and the CHP officer got spooked and ran right into my client very forcefully, knocked her on her head. She suffered actually a brain injury. And the car that was driving so erratically was driven by a deputy sheriff. So we sued the county and the state of California, and I pitted both against each other, and it worked very effectively. So that's one technique you can use. I'm running out of time, so I'll just wrap up. In your trials, in terms of resolution, that's the verdict. So in a book, it may be the trial, it may be finding the bad guy, but in a trial, it's the verdict. And I like to talk about the 3 C's when you're dealing with verdict forms in particular. Be clear, be concise, and cover all the material issues. Clear, concise, and cover all the material issues. And then the verdict will come back in a resolution that would hopefully be in your favor. So thank you all. I'm open to questions if anybody has questions.
Structure, at least as a lawyer, you very carefully structure what you're doing. As a writer, do you sort of think about theme, plot, everything, all these elements before you start writing and have it all charted out? Or do you kind of see where your inspiration takes you and then say, okay, this is fitting together and this is where this is going?
Yeah, there's a term that writers use called pantsers versus plotters. Pantsers are seat of the pants writers, And plotters can outline everything from beginning to end. I'm kind of a combination. So I will have an idea where I want it to go when I start writing the book. And then I get stuck. And I have to just kind of play it by ear and see what makes sense. I wish I could outline a book from beginning to end. Some writers do that. Richard North Patterson told me his outline for Degree of Guilt was 300 pages. That's my book. So it's
So do you know your theme as your, the page one, chapter one?
pretty much I know the theme. Yeah, I know I don't know the plot though. And I have a rough idea of some of the characters, but not all. Any other questions? Yeah. Yes, sir.
Were you a writer first, and then realized that translated to being a lawyer, or were you a lawyer first? And did you go, oh, I'm a storyteller here, so start writing as well?
The latter. I wish I was a writer first, then I would have taken writing courses. My first book wouldn't have taken me 10 years to write, because I didn't know what I was doing. No, I mean, some lawyer authors are authors first. Scott Turow went to the Stanford MBA program in creative writing, not MBA, MFA, Masters of Fine Arts. And he was a writer first. But it would make things a lot easier if I had done that. I had no training at all until I started writing, and then I would go to like the book passages programs in Marin and go to different seminars. Yeah. Over here.
So you gave a lot of examples from the plaintiff's lawyer's perspective. I wonder if, on the bench or otherwise, you've seen really effective plotting or character development from the defense side and how that was presented.
No. I presided over criminal trials. I was at the Hall of Justice for 5 years, and yeah, I'm being facetious. In the criminal trials that I presided over, I've seen some really good defense lawyers, who had a story to tell, and they would tell their. And the ones I remember the most were ones whose defense was clear at the very beginning. And they carried it through with their witnesses and their argument and everything else. The ones that I don't remember as well are ones where at the end of their case, or of that case and their defense, I would say, I don't understand their defense. And that happened a lot, where they weren't clear on exactly what the defense to these charges were. So, but the ones who are very clear at the beginning and use techniques like I've described, were very successful. There's another question in the back. Yeah.
I guess I wondered how your sympathy for a character or a client affects what you could bring forward imaginatively for that character. Does it affect, like, when you're writing, your engagement with that character, or do you notice an effect?
You mean like falling in love with a character?
Yeah, or putting yourself in their place and sort of picturing complexly what their experience is.
That's one of the biggest challenges in writing is, since most of my books are in first person, sometimes I get writer's block, so I get stuck. And I try to step back and think, what would this character do? What is consistent with that person's traits that makes sense? What conflict might develop in particular, and try to make it interesting to the reader. So there's an old saying that authors use, which is kill your darlings. Meaning you have a good character, you fall in love with them, you should kill them. Because that'll advance the story. I haven't done that yet. I mean, if I killed Dutch Francis, I wouldn't have much more to write about.
You did the nice description of the judge whose father appeared before the court, and I guess in trials, my perception is the appearance of the people is very important. Did you get into that in writing a lot? You know, I have a friend who's been on 8 juries. She's actually been on 8 juries. And she was like a 40-year paralegal. She's very conscientious. She said, I talked to her. The way she decides is usually based on who's better looking.
Oh, my goodness.
I mean,
That's a tough one. And what's your question?
I mean, when you write or when you do trials, either way you think would be appropriate. How do you do it? How do you deal with the extraordinarily attractive person versus the everyday person?
Yeah, I haven't actually thought about that. So I haven't really drawn characters with the idea this one's really attractive and how's that going to appear to a jury? Though in my first novel, Alibi, the defendant's a 16-year-old kid who I describe in such a way that you think he's guilty. Just the way he looks, the way he acts, his demeanor. And that's Judge Francis's first impression of him, that this kid must be guilty. And then you kind of go on from there and see if that's true or not. But that's an interesting question. I hadn't really thought much about how attractive a character is and how that affects perception. Any other? Yeah.
Have you noticed a change in your legal writing since you started writing books?
I write shorter books now. Alibi, I think, was 110,000 words. And Beneath the Gavel, 73,000 words. And I think I've cut out a lot of the stuff I used to put in. Side notes, subplots, some subplots, not all of them, but some, which really tightens the prose, I think. Yeah.
Do you write with an idea about adaptability to television or movies? And I know some modern authors who are successful are doing that, and they make most of their money, frankly, on the adaptation. Is that something that you worry about or think about?
I have thought about that. I've actually written a couple of screenplays based on my books, which I haven't tried to sell yet.
Mhm.
Yeah, that would be great. Have any connections in Hollywood?
No.
Not yet.
No,
So it is on your mind.
it is. Yeah. But, you know, these kinds of books, except unless you're John Grisham or Scott Turow or Michael Conley, you got a long shot. And all three I mentioned have stories out now on either Netflix or one of the other streaming services. All right, better wrap it up. Thank you.
Thank you, Judge Murphy, for coming.
You're welcome.
Thank you all for coming today. And please do have a evaluation sheet in your packet. If you wouldn't mind just filling that out, you can drop it off. We have a basket out here. We've also got copies of Judge Murphy's publications for sale here. You can, he's happy to stick around and sign them. So, please join us for that. And we have more programs coming up. You can sign up for our newsletter up at the front desk. And if you'd like any help in the library today, just let us know. We're happy to show you around and help you. Thank you for coming.
Thank you.